Shocking breaking news coming out of Washington in a stunning 6-3 decision. The Supreme Court has just delivered a ruling that could shatter decades-old federal powers, and the entire nation is reeling from the impact. This isn't just another legal decision buried in courthouse documents. This is a constitutional earthquake that's sending shockwaves through every level of government. And what's remarkable is that almost nobody saw it coming. Legal analysts across the political spectrum didn't predict a ruling this aggressive. Federal agencies, the ones who've operated with broad authority for over 50 years, didn't expect the court to go this far. Right now, Washington is rattled, newsrooms are scrambling, and state capitals are trying to figure out what just happened. This ruling isn't just a legal change or a technical adjustment to administrative procedure. This is a full-force strike at how federal power has operated for more than half a century. And the implications are staggering. What the court just dismantled affects regulations that touch every corner of American life, enforcement mechanisms that businesses have dealt with for generations, rulemaking processes that bypass elected representatives, and a very framework of how the federal government controls everything from the air you breathe to the products you buy. But here's what makes this even more explosive. If you think this ruling stops here, if you believe the justices are done reshaping federal power, you're not seeing the full picture. This decision opens the door to challenges that could unravel the entire administrative state as we know it. To understand why this ruling hits so hard, you need to understand the decades-long tension that's been building beneath the surface of American government. Federal agencies have steadily expanded their power through rulemaking, creating regulations that have the force of law without ever going through Congress. And they've done it in virtually every sector you can imagine. Energy policy, environmental standards, workplace safety, financial regulations, healthcare mandates, telecommunications rules, firearms restrictions, immigration enforcement. The list goes on and on. These agencies claimed authority to interpret vague congressional statutes and then used those interpretations to build massive regulatory empires that controlled trillions of dollars in economic activity. But cracks started appearing in this system. Courts in different circuits began ruling in conflicting ways. States started pushing back against federal overreach. Constitutional challenges multiplied as citizens, businesses, and local governments realized that unelected bureaucrats were making decisions that fundamentally altered their lives. The pressure kept building. This wasn't one isolated case or a single legal dispute. This was a mountain of conflicts erupting simultaneously across the country, creating a legal crisis that demanded resolution. Lower courts couldn't agree. Federal agencies kept pushing boundaries, and states were increasingly willing to fight back in ways they hadn't for decades. The tension reached a breaking point, and when the Supreme Court justices finally stepped in to resolve this mess, they didn't choose a cautious, moderate approach. They chose the most aggressive path imaginable. What did the court actually say in this 6:3 decision? The core message is stark and unambiguous. The Supreme Court declared that federal agencies have exceeded their lawful authority, that the powers they've been exercising for decades rest on unconstitutional foundations, and that a fundamental correction is necessary to restore proper separation of powers. And the tone of this opinion is what's catching everyone off guard. This wasn't a mild, cautious ruling hedged with exceptions and qualifications. The majority opinion was sharp, direct, and read like a warning shot across the bow of the entire federal bureaucracy. The justices made clear that they're not interested in incremental adjustments or technical fixes. They're demanding a wholesale rethinking of how federal power operates. The key shift comes down to this. The court insisted that only Congress, the elected legislative branch accountable to voters, can create laws with major national impact. Federal agencies can't simply claim broad interpretive authority, issue sweeping regulations based on vague statutory language, and then enforce those regulations as if they were laws passed through the democratic process. That era, according to this ruling, is over. Agencies must stay within clearly defined boundaries set by Congress. When major questions of policy arise, Congress must speak clearly and specifically. The days of agencies filling in the blanks with their own preferred policies are done. This ruling doesn't just adjust the legal system or tweak administrative procedures. It fundamentally changes who holds power in America, and it does so with a force that's leaving Washington stunned. Let's talk about what federal powers just collapsed under the weight of this decision because the practical implications are enormous. Broad regulatory authority that agencies claimed for decades, the ability to issue rules affecting millions of Americans without specific congressional authorization, has been severely restricted. Emergency rulemaking powers that allowed agencies to bypass normal procedures during claimed crises are now subject to much stricter scrutiny. The practice of using interpretive guidance to expand enforcement authority far beyond what statutes actually say has been challenged at its foundation. And expansive compliance requirements that agencies imposed through regulatory interpretation rather than clear legislative mandate are suddenly on shaky legal ground. Here's what this means in practical terms. What federal agencies once accomplished through internal rulemaking processes, what they did by issuing guidance documents and regulatory interpretations, now must pass constitutional scrutiny and demonstrate clear congressional authorization. Agencies can no longer claim they're just interpreting ambiguous statutes when they're actually making major policy decisions that affect the entire nation. The framework that allowed unelected officials to essentially legislate through regulation has been dismantled. And make no mistake about the magnitude of what just happened. Legal experts are calling this the biggest rollback of agency power in decades, possibly since the New Deal era. The administrative state, as it's existed for most of modern American history, just had its foundations shaken, and the aftershocks are only beginning. The impact of this ruling radiates outward from Washington to every state capital in the nation, and governors are suddenly facing a completely different power dynamic. States now have significantly more autonomy to challenge federal directives that previously would have been enforced through agency authority. Environmental regulations, commerce restrictions, transportation mandates, energy policies. All of these could be rewritten or challenged based on this new framework. Governors who've been fighting federal overreach for years suddenly have the Supreme Court backing their position that agencies went too far. Red state governors who resisted federal environmental rules. Blue state governors who wanted more local control over their own policies. They're all looking at this decision and realizing the balance of power just shifted dramatically. Federal agencies that once could impose one-size-fits-all regulations on all 50 states must now prove they have clear congressional authority to do so. And if that authority doesn't exist or isn't specific enough, states can push back with real legal force behind them. This isn't just theory or legal abstraction. This means policies affecting water rights, land use, business regulations, healthcare delivery, and countless other areas may be rewritten from the ground up. The assumption that federal agencies have the final word is gone. Frame it dramatically because this is dramatic. This ruling just returned huge chunks of authority back to the states, redistributed power away from Washington bureaucrats, and back toward locally elected officials. Whether the federal government likes it or not, the map of American federalism just got redrawn. But if states just gained power, Congress just got handed an enormous responsibility it hasn't had to fully shoulder in generations. And that's creating a political earthquake on Cap Hill. Under this new framework, Congress must write clearer, more specific, more detailed laws if it wants federal agencies to implement major policies. Lawmakers can no longer pass vague statutes filled with broad language and then let agencies figure out the details through rulemaking. That shortcut has been closed. Agencies can no longer interpret general congressional statements into massive regulatory powers that reshape entire industries. If Congress wants a major policy implemented, Congress must actually legislate that policy with specificity and clarity. And here's the shockwave rippling through Washington right now. This forces Congress to do its job, to engage in the hard work of crafting detailed legislation, negotiating specific provisions, and taking responsibility for policy outcomes. It strips away the shortcuts that have been used for generations, the practice of passing broad authorization bills, and letting agencies work out controversial details away from public scrutiny. Senators and representatives who got comfortable with vague legislative language and agency implementation are now being told they must be specific, detailed, and accountable. Many lawmakers weren't expecting this level of responsibility to land back on their desk. The Supreme Court just told Congress it can no longer outsource major policy decisions to unelected bureaucrats. And frankly, many members of Congress aren't prepared for what that means in practice. The legislative branch is about to get much busier, much more detailed, and much more accountable to voters for specific policy choices. So, who won and who lost in this monumental 6-3 decision? Let's be clear about the winners first. Individual citizens who've been subject to regulations they never voted for just gained new grounds to challenge federal overreach. Businesses that have struggled under layers of agency-imposed compliance requirements now have legal ammunition to fight back. States that have been battling federal agencies for more authority over their own affairs just got major Supreme Court backing. And citizens across the political spectrum who believe in democratic accountability and limiting unelected bureaucratic powers scored a massive victory. But make no mistake, there are clear losers in this decision. Federal agencies that built entire regulatory empires over decades just watched their foundations crumble. Executive branch power, the ability of the president to implement broad policy agendas through agency action rather than legislation, took a serious hit. Regulatory bureaucracies that employed thousands of people to write rules affecting millions of Americans must now operate within much tighter constraint. And policymakers who relied on agency authority to accomplish goals they couldn't get through Congress are suddenly facing a much harder path. Environmental advocates who used EPA regulations to implement climate policies Congress wouldn't pass are worried. Labor advocates who pushed OSHA to expand worker protections through rulemaking are concerned. Gun control advocates who hoped ATF regulations could restrict firearms without congressional action are alarmed. And civil rights advocates who relied on agency interpretations to expand protections are uncertain about the future. Frame it dramatically because this is the reality. This decision flips the power pyramid upside down, redistributes authority from unelected officials to elected representatives, and fundamentally alters who makes the rules that govern American life. But here's what makes this ruling even more explosive going forward. What happens next isn't a calm return to normal governance. What comes next is legal chaos on a scale we haven't seen in decades. Legal experts are already predicting a massive wave of lawsuits targeting agency decisions that relied on the old framework of broad agency authority. Every regulation, every enforcement action, every compliance requirement that was based on agency interpretation of vague statutory language is now potentially vulnerable to legal challenge. Businesses are dusting off cases they thought were settled. States are preparing new challenges to federal rules they previously accepted, and advocacy groups across the political spectrum are identifying regulations they want to overturn. Analysts are describing what they fear is coming. Regulations affecting environmental protection, workplace safety, financial markets, healthcare delivery, energy production, and countless other areas may collapse or face years of litigation. Old cases that were decided under the previous framework may be reopened with new legal arguments. New legal battles may explode simultaneously in courts nationwide, creating conflicting rulings and confusion until the Supreme Court steps in again to clarify. Federal agencies are scrambling to figure out which of their existing rules can survive this new scrutiny. Congress is realizing it may need to pass dozens or even hundreds of new laws to restore regulatory authority it thought already existed. And state governments are preparing for both new autonomy and new responsibilities as federal power recede. The 6-3 ruling announced today is not the end of this story. It's not even the middle. This is the beginning of a legal earthquake that could reshape the entire nation, redefine the balance between federal and state power, force Congress to reclaim its constitutional role, and fundamentally alter how America is governed for generations to come.